Well, folks, we got the Judge Sukowitz memorandum of decision in order. The defendant is back before the circuit court with post-conviction motion pursuant to Wisconsin Statute 9706. Through his attorneys, Kathleen Zellner, Associates, PC, the defendant asserts that the newly discovered witness statements will establish there is a viable third-party suspect for this offense. The defendant asserts that evidence regarding the third-party suspect was never presented at the time of trial, and the failure of the presentation of the alternative suspect undermines the confidence in the jury verdict. The defendant further asserts that the state violated the provisions of Brady versus Maryland. If the court rules that the third-party suspect evidence does not meet the requirements to grant relief pursuant to his request post-conviction relief, the defendant asked that, alternatively, the court grant him a new trial in the interest of justice. Facts. The court will not recount the full record in this voluminous case. The facts have been set forth in numerous filings in prior court proceedings. The court will refer only to the facts alleged in the current motion before the court. Prior to the commencement of the trial of 2006, the trial court entered an order requiring the defense to identify any individuals other than Brendan Dassey that it intended to suggest was a third party responsible for any of the crimes charged against the defendant. Furthermore, the court stated that the admissibility of evidence regarding the potential third-party suspect would be required to meet all standards set forth in the ruling. The defendant provided notice that would assert that there was a reasonable possibility that others committed the murder with which he was charged, including Scott Tadich, Andrews Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. In addition, the defendant argued that the ruling in Denny did not apply to his trial and that if it did, he should be permitted to present evidence regarding several alternative suspects. The trial court that the standard set forth in Denny did apply to the defendant's evidentiary offering and noted that in the absence of motive, it could be more difficult to offer evidence that would be relevant to material to the third person having committed the crime. The court concluded that nothing in the defendant's offer went beyond the level of speculation. The court stated that while the defendant identified many people with the opportunity to commit the murder, no clear motive for the crime was identified for any of the alternative suspects, failing to meet the Denny standards. After the defendant was convicted of this murder, he filed the post-conviction motion pursuant to Wisconsin Statute 97406. The court concluded that while the defendant may have supplied evidence as to motive to frame the defendant, none of the evidence identified motive for Bobby Dassey to be the murder of Teresa Halbach. Without establishing any evidence of motive, the court concluded that Mr. Dassey was precluded from being named as potential suspect under Denny. The Wisconsin Supreme Court allowed the decision to stand. Several other post-conviction motions were filed, denied, and upheld by the appellate courts. The Court of Appeals ruled on the defendant's last post-conviction motion in July 28, of 2021, upholding the circuit court's decision. The court found that the content of the defendant's motion was insufficient to entitle him to a hearing of these claims, procedurally barred. While the motion was pending before the Court of Appeals, the defendant requested that the court stay its decision and remand the matter back to the circuit court for evaluation of the new claim. The Court of Appeals noted the defendant was asserting a Brady violation involving the affidavit of witnesses Thomas Lewinsky. In his affidavit, Mr. Lewinsky asserted that he saw Bobby Dassey in possession of the victim's vehicle several days after the murder. Mr. Lewinsky stated that he called the Manitowoc Sheriff's Department later that day to report that he saw was dismissed by the deputy. In the decision on July 2021, the Court of Appeals stated that the defendant's newest claims regarding Brady violation had little to no relation to the claims before the court in that appeal. The court stated that the issue should be resolved in a separate post-conviction before the circuit court. The court further stated, as discussed below, we are not addressing Avery's most recent filing in the court. See our decision, motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise a claim, he will need to bring this in the new Wisconsin Statute 9706 motion. That motion would need to be survived both Alonga and Naranjo scrutiny and be found to have merit, in which case the evidence presented might supply the missing direct connection in the event that VLCD evidence might have relevant to the showing of Dassey's motive and might bear on whether Dassey is or should have been viable Denny suspect. We express no opinion on the merit of any such 97406 motion, as all such issues would be for the Circuit Court to decide in the first instance. As a result of the ruling, the defendant asserts by failing to disclose his statement to Ms. Lewinsky to the defendant, the state withheld exculpatory evidence from the defense in violation of Brady rule. Furthermore, the defendant states that the evidence supplied by Ms. Lewinsky creates a direct link between Bobby Dassey and the murder of the victim. As such, the defendant asserts that it was denied the opportunity to present evidence of the viable third-party suspect at his trial. By denying the defendant that the opportunity to present that defense at his criminal trial, he argues that the issues in this case were not fully tried and that had the jury been presented with his testimony, the verdict in this case would likely have been different. The defendant is now asking the court to review the aforementioned claims and grant the evident relief, or in an alternative, grant him a new trial in the interest of justice. Analysis. For the affidavit of Ms. Lewinsky to be admitted as evidence establishing Bobby Dassey as a valid third-party suspect in the murder of Ms. Halbach, the defendant must satisfy two separate tests. The test is Denny Supra requires that the defendant show that the third party had legitimate tendency to commit the crime at issue. To meet this burden, the defendant must show that the third party had a motive to commit the crime, the opportunity to commit the crime, and that there's no some direct evidence linking the party to the crime, does not remote in time, place, or circumstances. The defendant also raises and incorrectly identifies that the test set forth in State v. Edmonds also applies to the admissibility and affidavit itself. The Edmonds court established a four-part test. No determined evidence is newly discovered and admissible for consideration by the court. First, the evidence must have been discovered after the defendant's conviction, which it was. Second, the defendant must have established that he is not negligent in seeking out the evidence in the question. Well, I'm just going to read. Third, the defendant must establish the evidence and material in the issue in the case. Fourth and finally, the defendant must prove the evidence offered is not merely cumulative and already in the court record. The defendant further notes that only if these four requirements are met is the circuit court required to determine whether a reasonable probability exists that a different result would be reached in a new trial. In his affidavit, Ms. Lewinsky states that early in the morning of November 5th, 2005, he was delivering newspapers to Savory Salvage Yard in the course of his employment. Prior to actually delivering newspapers, Ms. Lewinsky states that he encountered Bobby Dassey and an older, unidentified man pushing a dark blue RAV4 down Avery Road towards the junkyard. Ms. Lewinsky stated that the car did not have its lights on. After delivering the newspapers to the Avery mailboxes, Mr. Lewinsky states that he drove back towards the exit where Bobby and the older gentleman and the car still were. Mr. Lewinsky states that Bobby then stepped in front of the vehicle in an attempt to stop him from leaving the property. He further states that the headlights were shining directly on Mr. Dassey at this point. Mr. Lewinsky then states he came within 5 feet of Bobby Dassey, who looked unhappy to see him on the road, and was forced to swerve into the ditch to avoid him. Fearing for his safety, Mr. Lewinsky called out, "Paperboy, gotta go," and drove towards the exit. After learning that Ms. Halbach's car was found on the property, Mr. Lewinsky states that he realized the importance of what he had seen and immediately contacted Manitowoc County Sheriff's Department to report the encounter. Mr. Lewinsky then states, after viewing the television show Making of a Murder, he contacted the Innocence Project in New York to report the incident again. Finally, in 2020, Mr. Lewinsky contacted the defendant's current counsel and the current affidavit was drafted. With respect to the first requirement of Edmonds' test, defendant states that Mr. Lewinsky did not come forward and contact the defendant's counsel until April 2021. In his corrected affidavit, Mr. Lewinsky states that he originally believed that he contacted the defendant's counsel in 2016. However, it was later discovered that Mr. Lewinsky actually sent the communication to the Innocence Project in New York. Counsel states that the information was not relayed to the current defense team at the time. The defendant asserts that despite the numerous discovery requests filed by his original trial counsel, the record of the call Mr. Lewinsky made to Manitowoc Sheriff's Department was not turned over to them until after Lewinsky came forward in 2021, and an additional specific discovery request was made. For the purpose of this test only, the court will conclude that the evidence in the Lewinsky affidavit was discovered by counsel after the defendant's conviction, satisfying the first requirement of the Edmonds test. The defendant next addresses the second standard of the Edmonds test. The defense asserts that it was not negligent in seeking out the evidence set forth in Mr. Lewinsky's affidavit. Prior to Mr. Lewinsky's contact with attorneys in 2021, the defense states that he had no way of knowing that such an account of events existed. The log of the call that Mr. Lewinsky made to Manitowoc County Sheriff's Department was not turned over to trial counsel in spite of numerous discovery requests. Neither trial nor appellate counsel was on notice that any such contact occurred. The record of the call was only delivered to current defense counsel after Lewinsky contacted the team directly, and the team specifically requested records of contacts between Mr. Lewinsky and Manitowoc County Sheriff's Department in order to verify this as assertion made in the affidavit. Based on these facts, the defendant has met requirements and satisfied the second of the Edmonds test. The third standard of Edmonds requires that the defendant establish that the new evidence offered in the materials in the issue of the defendant's case. The evidence submitted as being material to the defendant's motion goes to the theory that a third person committed the crime for which the defendant was convicted of. For evidence to be admitted and established that the third party committed a crime rather than accused, the evidence must meet the test set forth in the Denny. For evidence to meet the Denny test, the evidence offered must show that there is a legitimate tendency that the third party committed the crime alleged. More specifically, the evidence must establish that the third party had motive, opportunity, and direct connection to the commission of the crime itself, while the defendant does not have to prove the guilt of the third party at the level of which sustained conviction. Evidence that simply affords a possible ground of suspicion against the third party is not admissible. The defendant asserts that the evidence in the Lewinsky affidavit established a direct link between Bobby Dassey and the murder of the victim by linking Bobby Dassey directly to the vehicle driven by the victim. The defendant asserts additional evidence, previously discounted in the case, may then be reconsidered by the court, further supporting the third-party suspect theory. The defendant argues that the previous excluded evidence includes CD copy of the computer hard drive found in Bobby Dassey's home. The defendant urges the CD, which contains searches of terms of subjects, including images of violent pornography, would establish a sexual motive for Bobby Dassey to have committed the crime. The defendant argues that the Lewinsky affidavit also established that Bobby Dassey had the opportunity not only to have committed the murder of Ms. Hallbach, but also to plant evidence, including the defendant's blood and DNA in the victim's RAV4. Further, the defense argues that Mr. Dassey's possession of the RAV4 also provided him access to the key to the victim's car found in the defendant's home, as well as the victim's electronics found in the burn barrel, along with the victim's remains. The defendant finally asserts that the information of the Lewinsky affidavit could impeach the testimony that Bobby Dassey gave at trial, in which he stated the victim never left the property unless seen heading towards the defendant's trailer. With respect to the motion element of the Denny test, the defendant argues that the state clearly considered sexual assault with a motive for murder, as evidenced by the seizure of the family computer of the Dassey home. The defendant asserts that the evidence of Mr. Dassey's motive to commit murder was contained on the hard drive of the computer, which was copied onto a CD referred as the Veely CD. The defendant cites that the decision of the Court of Appeals in which the court stated that the content of the Veely CD may become relevant to the defendant's motion if the defendant could prove a direct connection between Mr. Dassey and the murder committed. The defendant then goes into a lengthy argument as how to the evidence found in the Dassey family computer established the motive for Mr. Dassey to have committed the murder of Ms. Hallbach. The defendant asserts that the search for the words and images found on the Dassey computer show an obsession with violence and killing. The defendant further states that the images deleted from the computer were pornographic in nature and depicted violent images of torture and mutilation of young females. The defendant then refers to the affidavit of Brad Dassey, half-brother of Bobby, who states that he had a conversation with Barbara Dassey, Bobby's mother, in which she stated that she hired someone to delete the files from the computer in question. The defendant hired an expert to examine the Dassey family computer. His expert, Mr. Hunt, states that they discovered 8 periods of time close to the date of the murder from which files were missing and presumably deleted. The defendant then states that Special Agent Thomas Fassbender examined the VLCD and in his report described media that he found on the disk. Images of the victim of the defendant was April 18th date of 2006. Images of nudity of both sexes, including pornography depicting bondage, possible torture, and pain. He further stated that the other images on the CD included those of pornography, including the acts between humans and animals, images of young women, injured and mutilated people. The defendant then asserts that the record contains sufficient evidence to prove that Bobby Dassey was the only one member of the household at the home during the certain days and hours when the searches were conducted. The defendant bases this conclusion on the self-reported routine schedule of all other members of the Dassey family that would have kept them out of the house at the time searches were conducted. Based on those routine schedules, the defendant asserts that every other member of the family living in the Dassey house was excluded from conducting the incriminating searches, as only Bobby could have researched these violent and pornography images found on the family computer. The defendant asserts that he, too, must be eliminated as the person who conducted the searches because he had no access to the Dassey home and did not have any passwords in the computer. As further proof that he could not have conducted the computer searches, the defendant notes that most of the violent pornography images discovered were accessed after he was taken into custody on November 9, 2005, and that Brendan Dassey, also convicted of the crimes related to this murder, was in custody on March 1, 2006, when more of the most violent images were searched. The defendant further cites a Bobby testimony at trial in which he stated he was home alone and asleep from 6:30 a.m. to 2:30 p.m. October 31st, 2005, because there were searches done on the Dassey family computer during those hours. The defendant asserts that the only conclusion that can be drawn is that Bobby conducted those searches. The defendant also refers to the documentation of the interview of Bobby taken on November 17, 2017, in which he stated that the family computer was located on the desk in the living room of the Dassey home at the time. Bobby further denied that the computer was ever located in his bedroom. However, crime scene photos taken on November 12th, and don't forget the video we have too, Judge Suck at this, show the computer in that location. The defendant further cites in the affidavit taken on June 25th, 2018, in which Bobby's brother, Blaine, stated that the family computer was located in Bobby's room and Bobby was the primary user. Based on that evidence, the defendant asserts that the violent pornography images researched by Bobby were conducted sufficiently close in time and were sufficiently similar in manner to the murder to establish a motive for Bobby to have committed a crime. The defendant relies on Dressler and Ms. McCaughey for the proposition of this act's evidence admits the evidence could be proof of the defendant's motive, intent, and plan to murder the victim. The defendant quotes Dressler's decision in support for his claim. The fact that the defendant maintained a collection of videos, pictures depicting intentional violence is probative to the state's claim that the obsession with the subject. A person obsessed with violence is more likely to commit murder. Therefore, the videos and photographs are relevant. Based on Dressler's ruling, the defendant asserts that the court should find Bobby Dassey's obsession with violent pornography images made him more likely to have committed murder, establishing his motive in the case. In further support of the assertions of the defendant cites the report of the expert, Dr. Burgess, states in an affidavit that there is well-established causal connection between pornography consumption and violent behaviors. The defendant further refers to the affidavit submitted in prior motion submitted by former FBI agent Greg McCary, in which he offered his opinion that the searches for violent, underage, and child pornography, combined with the images searched for the dead bodies, reflects a comorbidity of sexual paraphernalia. Agent Gregg further concluded that Bobby was becoming socially deviant in the viewing of violent pornography in the weeks before Miss Halbach's murder. The state disputes the conclusions drawn in the defendant's argument, asserting that the defendant is misrepresenting the facts of the case. This is why she wants an evidentiary hearing, so she can fucking verify if they are facts or not. The state argues that the defendant has fallen short of establishing Bobby Dassey was, in fact, the person who conducted the computer searches in question, or that the searches conducted were probative and relevant to prove that anyone had motive to commit the murder of October 2005. The state argues that, once again, the defendant failed to establish that Bobby Dassey conducted any of the searches cited by the defendant. Referring back to a previous decision issued by the Court of Appeals, the state recounted the court's conclusion that the mere fact that Bobby could have been home alone when some of the searches were conducted was not conclusive evidence that he did in fact conduct the searches. The defendant, the court continued, cannot rely on the opinion of a computer expert on anyone else's speculation as to what Mr. Dassey's actual schedule was on that particular day in question, a fact which applies to other family members as well. The state notes that there are no citations in any facts or recording establishing Mr. Dassey's whereabouts at the time the searches were conducted, or evidence was conclusively established that another person had access to the home computer at the time in question. Furthermore, the state notes that the defendant provided no citations of the record of specific images that could be directly related to the criminal crime committed, or identify how any of the images were relevant to any specific individual having motive to commit murder. Referring again to the Court of Appeals decision, the state notes that the court previously concluded that the existence of the searches during the time Mr. Dassey was usually at home is not a fact that would establish conclusively that he was actually in the home at the time, let alone that he was the person using the computer accessing these images. The state further disputes the defendant's conclusion that the law enforcement considered pornography and sexual assault as the motive for the murder of the matter. The state notes that during any criminal investigation, law enforcement collects all potential evidence that could possibly be relevant to the case, but not in this instance. The evidence is then analyzed for a determination as to whether it has been hearing on the crime committed. Mere fact that the investigator sees the computer does not prove the theory of the case. The state asserts that any relevance assigned by the defendant to seize computer unsupported speculation. The state also argues that the images and terms found during the computer search and cited by the defendant as evidence of motive for murder and similar to what actually occurred during the commission of the crime are not relevant to proving the motive for anyone, including Mr. Dassey. The state asserts that someone having conducted a search for terms like news, body, journal, cement, which are very general and not specifically related to the crime, does not show the searcher had a propensity to commit a specific crime. The state notes that the defendant's own exhibits show that the majority of the searches for pornography and violent graphic images had no direct similarity to the manner in which the crime was committed. The further points out that most of the searches referred to by the defense occurred on a weekend when anyone in the house could have accessed the family computer, while other searches occurred after 3:45 p.m. on a weekday when Blaine would have been access to the computer as well. Additionally, the state points out that the defendant's timeline in which he asserts that Bobby was the only person who would have conducted the searches does not account for the time when Wichita School District's spring break took place, between March 24th, 2005 and March 30th, 2005. Okay. Blaine, Brendan, and anyone invited over by the boys could have accessed the computer between April 7th, 2006 and April 18th. Brendan Dassey was in jail in 2006. So, yeah. The state goes on to argue that 128 searches listed and relied upon by the defendant evidence the motive. Only 28 of those occurred during the time that it is alleged that only Bobby Dassey could have accessed the computer. Furthermore, of those searches, only 3 of the searches occurred prior to Ms. Halbach's murder, assuming that the purpose of this motion that these 3 searches were conducted by Bobby Dassey. The state argues that the mere 3 searches conducted prior to the murder of Ms. Halbach failed to demonstrate that Mr. Dassey was a voracious consumer of violent pornography prior to the murder, thus failing to establish the theory of motive offered by the defendant. Addressing the defendant's citation addressed in McCautry, the state argues that the defendant's relevance to the ruling is misplaced for a number of reasons. First, the state argues that the ruling in Dressler was made in a habeas corpus proceeding and is not binding in Wisconsin criminal law. Second, the state argues that the fact that the Dressler case presents a vast departure from those in the case before the court. The male victim was murdered in an extremely specific manner, that including binding, mutilation, and dismemberment. While investigating the crime, law enforcement searched the defendant's home, discovered many weapons and restraints, along with pictures, magazines, and videos depicting similar murdered and mutilated victims, as well as the homosexual pornography. These items were offered at trial as other acts of evidence in support of providing the defendant's intent, motive, and plan to assault and kill the victim in a specific manner depicted in images found in the defendant's possession. The state argues that the facts in the case at bar and those in Dressler are substantially different. In Dressler, the state notes that there is no dispute that physical evidence belonged to the defendant and was in exclusive possession. In this matter, the state argues that the defendant has not provided any facts to prove that Bobby Dassey was the person in possession of the pornography alleged to be the motive for the murder or had exclusive access to the computer. In addition, the pornography images discovered in the Dressler case very closely mirrored the evidence discovered at the crime scene itself. The state argues that the defendant neither submitted any images taken from the Dassey computer that show an individual who was shot and burned, nor any pornographic images that despite the accident similar to the Hallbach murder. Furthermore, the state argues that the search terms cited the evidence of the motive for murder in general and do not specifically relate to the crime committed in this matter. Finally, the state notes that all the violent images and pornography found in the Dressler case were in exclusive possession of the perpetrator before the murder occurred. The media evidence in Dressler, state argues, showed a prior disposition to commit the crime in a great similarity to the actual crime itself. Because the evidence was possession of the defendant prior to the crime having been committed, the state argues that it did not in fact demonstrate a motive, plan, and intent to commit the crime as alleged. In the case at bar, the state points out that the vast majority of computer evidence relied upon the defendant to prove Bobby's motive to kill was obtained during searches conducted after Mr. Hallbach was murdered. The state further states that the images and search results from the Dassey computer, but not directly mirror the manner in which the victim was killed. Unlike the defendant in Dressler, the state notes that the evidence offered by the defendant as proof of motive cannot be proved to have obtained by the or have been in the sole possession of Bobby Dassey. To the extent that the defendant's submission established anything that the state alleges and demonstrates the defendant cannot meet admissibility standards, the court in Sullivan ruled that for other acts of evidence admissible, the evidence must be submitted for a principal purpose, it must be relevant, and that the probative value must not be outweighed by unfair prejudice. While motive is a principal purpose for which evidence can be used, the state contends that the defendant has not established that the evidence he offers is relevant to this matter. The state notes that the Court of Appeals rejected the argument that the image of the Dassey computer depicted any situations that were similar to the crime scene in the Hallbach murder. The state argues that there is nothing about the evidence found in the communal family computer is relevant as to proof of the motive prior to the commission of the crime. The computer information was collected along after the murder. Nothing in the evidence submitted, state asserts, makes it more like or less likely that Bobby Dassey committed the murder the defendant alleges. The state also argues that because there is a lack of similarity to the crime committed as the searches were done after the crime was committed, the prejudicial value of the evidence offered outweighs its probative value because there's no direct link to the motive or any evidentiary similarity between the computer evidence and the crime committed. The state argues that the jury could have convicted Bobby Dassey on illegally admissible evidence if such evidence were submitted to the jury. The state argues that the jury could conclude that the individual who searched for such images was inherently a bad person and convicted on the basis alone, rather than the applicable law. A review of the record of the defendant's argument revealed that he's failed to satisfy the third standard, the Edmonds test, as well as the motive element, the Denny test, which respect to the Edmonds test, the defendant argued that the evidence offered was material to an issue in the case because it established that the valuable third-party suspect could have committed the murder of Miss Halbach, and such evidence was never presented to the jury for consideration. Undermining confidence in the verdict reached, in order to meet the burden, the defendant has proved the evidence also met the standards set forth in Denny. To be admissible as a proof of the third-party suspect, the defendant failed to establish that Bobby Dassey had requisite motive to commit the murder of Miss Halbach. The defendant rests his motive arguments on the premise that Bobby Dassey had an obsession with violent sexual pornography, including young women, and a fascination with gruesome homicides and death. However, the defendant's arguments are not supported by evidence submitted. As the Court of Appeals has already concluded, the defendant did not establish that it was Bobby Dassey who conducted the searches in the question. The Court of Appeals ruled that if the defendant is correct as to what the usual schedules of the Dassey family members were, those general schedules are not proof establishing where any specific member of the family was on any given day. While the defendant argues that nothing short of recording of Bobby Dassey conducting the searches of the computer would satisfy the standard of proof demanded by the state, this assertion is not true. The defendant could have offered any piece of evidence that during the time in question, Mr. Dassey entered some type of identifier unique to him, such as a specific username or password, to establish that it was. In fact, the person using the computer to conduct these searches cited, the defendant could have offered a witness who saw Mr. Dassey actually conducting any of the searches in question. Even more simply, the defendant could have offered evidence that the defendant was actually home at the time of the searches rather than speculate based on typical schedules of the family to prove Mr. Dassey conducted the searches. The Court of Appeals has already concluded that the mere fact that Mr. Dassey may have been home during the time that the searches were conducted was not conclusive proof that he was the person who was actually conducting the searches that the defendant relies upon to prove motive for murder. The defendant reliance on the dresser is misplaced. The facts of the dresser were substantially different from those in this current case. The defendant and dresser was shown to have very specific images in his possession and closely mirrored the evidence found at the crime scene. Instruments involved in the murder were found in the defendant's exclusive possession. The totality of the evidence proved that the defendant was in possession of the incriminating evidence prior to the commission of the crime. In this case, the images in the term searched by someone in the Dassey home and the family computer did not closely mirror either the method of the murder or the disposal of the remains of the case. The searches offered, the defendant referred to generalized violent pornography in term searches, so no search results offered the defendant directly mirror the elements of the crime in the case. There's no evidence, only generalized an assumption that Bobby Dassey was the individual who conducted the searches on the family computer. The computer was not exclusively in possession of the Bobby Dassey prior to any of the murder. Only a very small number of searches were conducted prior to the murder of Ms. Halbach. No physical evidence directly linking Brian Dassey to the homicide was found in the house. Why did they mention Brian? Okay, no physical evidence directly linking Brian Dassey was found in the house. The defendant offers argument that Bobby Dassey was predisposition to commit the crime based on addiction to violent pornography. The defense offers two experts to discuss the role of pornography in commission of the crime. Putting aside any question as to the qualification of the experts to opine in this matter, both of the conclusions reached by experts depend on the assumption that Bobby Dassey was the individual researching the pornography on the computers, and the fact that not establishes the murder matter. Furthermore, the experts reached their conclusion without doing any forensic or psychological examination of Bobby Dassey in person. Their conclusions as to his mental state are based on evidence that is not admissible in this matter. The defendant has not met the burden. Denny established that Bobby Dassey had motive to commit the crime alleged, as this failed to meet the burden to admit the evidence offered to prove existence of the third party suspected for the commission of the crime. Without such a finding, the defendant cannot meet the third element of evidence establishing the evidence as material in the case. As previously noted, evidence simply affords a possibility ground of suspicions against the third party is not admissible. Even if the defendant met the burden with respect to the motive element of the Denny test, he has not met the burden with respect to the element of opportunity under the same test. The defendant asserts that the legal term of opportunity is broad and encompasses other acts of evidence that may otherwise be inadmissible. The defendant states the opportunity can include an individual's physical presence at the crime scene, the proof the individual had requested skill, capacity, ability to carry out an act. The defendant also notes that the incumbent of the proponent of the evidence shows relevance to evidence offered. The defendant notes that Mr. Dassey was present on the Avery family property on the day that Ms. Hallbach's murder took place. The defendant then refers to the affidavit of Ms. Sawinski to further support his arguments. The defendant argues that the affidavit of Ms. Sawinski established that because Bobby had possession of the RAV4, he therefore had access to evidence the defendant asserts the plan to defame him. Sixthly, evidence asserts that Bobby's possession of the RAV4 gave him access to the key found in the defendant's home and the victim's personal electronics found on the burn barrel. The defendant further states that Mr. Dassey had access to the blood because on November 3, 2005, the defendant reopened the cut on his finger and dripped a substantial amount of blood in the bathroom sink, on the bathroom floor, in his car, on the trailer, in his truck. The defendant then states that he went to the Dassey residence, asked Bobby if you brothers would like to go to Menards with him and a brother. According to the defendant, Bobby decided he had to stay behind because he had something important to do. It was also at the time that the defendant states that Bobby saw the open cut on his hand. They also mentions that the cops were just there looking for the woman that was just there on Monday. The defendant states that he left for Menards. He left his trailer unlocked, and upon leaving, he saw taillights in the vehicle near his trailer. He also mentions in his November 9th interview that it possibly could have been Bobby Dassey going that way because they used that way to get out of the property. The state agrees that in some instances an individual can be implicated in a crime by the mere proximity of the crime scenes. However, in a matter before the court, the state argues that the defendant is offering a much more complicated scenario as to Mr. Dassey's opportunity to commit the crime. Referring to the defense argument in order to satisfy the Denny test, the state asserts that the defendant must offer evidence that Mr. Dassey had skills, contacts, tools, time, and other means necessary. Well, he's a hunter. He has all the tools you need to dismember a body. The defendant must provide evidence of third-party realistic the ability to engineer such a scenario. The state argues that the defendant failed to meet that the burden in this matter. The state asserts that the defendant offered no evidence to establish that Bobby had the opportunity to successfully orchestrate this extremely complicated scheme to frame his uncle. The state argues that the complete absence of any necessary facts to support the defendant's arguments demonstrates that the defendant has insufficient evidence to show that Bobby had an opportunity to kill Miss Hallbach and frame the defendant in the manner in the defense claims. The state goes on to argue that the defendant has offered no evidence to establish that Bobby has the necessary skills and availability to manipulate the evidence in a manner that would implicate the defendant. The state notes at the time of the murder, Bobby Dassey was an 18-year-old high school graduate with no criminal record. Mr. Dassey was employed as a third-shift worker at the furniture factory. The state posits that there is no evidence of record that establishes how an individual of Bobby's age and experience would have obtained scientific knowledge or skill to collect, transport, and plant the defendant's blood from his bathroom. The state notes that nothing in the record indicates how Mr. Dassey would have obtained this necessary materials to collect to have transfer evidence in a manner successfully, as well in the manner not detected after analysis of the crime lab. The state points out that the defendant, in his brief in chief, does not address how Bobby transferred touch DNA to the victim's car. Furthermore, the state notes that the defendant does not explain how Bobby could have kidnapped Miss Hallbach, then hid her body in her car within minutes of being seen on highway at approximately 3 p.m. Referring to the record, the state asserts that it contains no explanation of the evidence establishing how the individual of Bobby's age, education, and experience discovered a tiny mangled bullet fragment that knew the victim's DNA on it planted in the garage. Well, I see how she just missed over the affidavit of his brother stating that he's seen Bobby driving a car that was not his Blazer. But and there was garage vehicles during and after the time, and the state additionally argues that there's nothing to the record explaining and supporting the theory that Bobby moved the victim's body and burned it at some undisclosed location, like the Manitowoc Quarry, and they moved the bone fragments from almost every bone in the human body back to the burn pit on the neighbor property undetected. Well, the defendant asserts that Bobby planted the key in the victim's RAV4 in a trailer between November 3rd and November 5th. The state notes that there is no explanation as to how Bobby could have moved the car from the property without the keys, driven away from the property, walked back to the property and replaced the keys in the defendant's trailer without anyone noticing. Well, I got a scenario for you, Judge. Suck at this. In the early morning, after the car's been planted back on the property, everybody leaves to go up to Crivets. That leaves Bobby Dassey at the end of that cul-de-sac all by himself with access to everything. Just saying. The Wilson test requires the defendant must provide evidence that Bobby Dassey has realistic ability to carry out the complicated plan it alleges was used to frame the defendant. The defendant speculates on many points as to how Bobby could have carried out the plan to frame his uncle. Well, I know how he carried it out because he had the help of law enforcement. But the Wilson test requires more. The defendant has failed to offer any evidence that Bobby has sufficient knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had the skill to plant the evidence and that the way would stand up in a scientific scrutiny by professional crime science scene analysis. The defendant offers no evidence supporting the claim that the Bobby had requisite knowledge to create and execute the elaborate plan to commit the murder and frame his uncle. The defendant further failed to offer any facts to record establishing a consistent plan to frame the defendant or any theory including law enforcement involved which implicates the defendant in the crime. The defendant theory that Bobby framed for the murder also fails to acknowledge the specific fact in relation to the crime, in which Brendan Dassey confessed he was convicted of participating in the murder of Ms. Hallbach. Brendan specifically implicated the defendant in this crime, and is convicted has been affirmed by the appellate courts and remains of record. All of the allegations implicating Bobby in the murder and the framing of the defendant are pure speculation and not supported by MVM submitted by the defendant. As such, the defendant failed to satisfy the test at Edmonds. Finally, the defendant asserts that Sawinski affidavit supplies a direct connection between Bobby and the murder of Ms. Hallbach. The defendant asserts that because Bobby was in possession of the victim's car and proves that he has access to the key to the defendant's car electronics. Well, the state, you guys claim that the car never left the property. And now we got a car being brought onto the property of a vehicle that you claim never left the property. So, yeah. Assuming that the purpose of the motion, the defendant, and everything inferred in the Sawinski affidavit is true, the defendant is incorrect in the assertion that the facts in the affidavit provide a direct link between Bobby and the Hallbach murder. You gotta be fucking kidding me. The defendant asserts that, ipso facto, if Bobby was in possession of the victim's car that night, he must also have been an individual who committed the murder. No evidence submitted by the defendant supports the conclusion. Even if the Bobby was found in possession of the victim's automobile on the night of November 5th, there is no only speculation that you gotta be no, this shit is fucking stupid. Sorry. November 5th, 2005, there's only speculation and no evidence to prove that Bobby was in possession of the car or that he had exclusive control over the vehicle prior to that night. The defendant further asserts that Bobby's possession of the car gave him access to the victim's car key. Well, obviously, if you're seen with possession of the vehicle, you're going to have the key to the motherfucker. And the speculation by the defendant, Mr. Sawinski, affidavit, does not mention seeing Bobby with the key to... Are you fucking kidding me? No, this is... In fact, the affidavit established that Bobby was pushing the victim's car without power on the night. How you going to push a car without a key to ignition? You ain't going to be able to steer the motherfucker. This is just fucking stupid. I can't wait to Zellner fucking rips this shit apart and goes to the Court of Appeals with this bullshit. Placing doubt in whether it's... I just feel bad, man. The affidavit does not mention Mr. Sawinski saw Bobby with the defendant's personal electronics. There is no evidence that it was there in the car. The only time that it was linked to Bobby and Mr. Sawinski. Neither the key nor the electronics were linked by any witness or by forensic evidence to Bobby. The victim's key and electronics could have been taken directly from the victim or taken from her car at any time prior to or after the murder by another individual long before the auto was in Bobby's possession. There is no evidence or record taken from the car that links Bobby directly to the actual homicide of Miss Halbach. The Sawinski affidavit, taken as true for purpose of the motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself. Nothing in the affidavit establishes that Bobby was in possession of the evidence that the defendant asserts was used to frame the defendant. No forensic evidence was found in the car that directly linked Bobby to the murder. No evidence of the record established that Bobby had exclusive possession of the victim's vehicle prior to the night that Mr. Sawinski saw him on the road, or that Bobby had control over the vehicle prior to the date. None of the physical evidence presented at trial or subsequently links Bobby Dassey to... How could it be presented at trial when we didn't find about this until 2021? While the defendant asserts that the only logical conclusion to be drawn from Bobby's possession of the vehicle that night is Bobby was the individual who actually murdered Miss Halbach, an assumption is flawed. There are other reasons that Bobby could have been in possession of the car that night. Really? And what would you like them to be? You're going to list them, I hope, including that Bobby was trying to help hide the evidence to protect the two individuals directly linked by forensic evidence to this murder and convicted of the crime. The defendant's conclusory assumptions drawn from the evidence offered in this affidavit do not amount to evidence directly linking Bobby to the homicide itself. As such, defendant failed to meet the final standard Denny test established Bobby as failed third-party suspect in this crime. The defendant also alleged that the state committed a Brady violation by failing to turn over the record of the phone call Mr. Sawinski made to Manitowoc County. There was never a report filed about it. And for 16 and a half years, they were telling us that the audio didn't exist. They even told Kathleen Zellner this. And then what happens? The clerk of court retires, we get a new sheriff, and what do you know? Now we have all that info that we claim we never kept record. With respect to the second and third prongs of the Brady test, the court addressed whether the evidence was favorable to the defendant, to the purpose was offered, and whether it was material to issue at trial. It was concluded that the evidence did not meet either of those. The evidence didn't even fucking exist at the time. It didn't even exist at the end of his trial, or during his trial, prior to his trial, after he's convicted, after all of his appeals. With respect to the statement of Kevin Ramlow, cited in his brief, the defendant notes in paragraph 118 of the brief in chief, the statement was submitted to the court in a motion to reconsider the October 2017 ruling denying his second post-conviction motion. The defendant asserts that the claim should not be procedurally under the ruling. While the court did not specifically address every document or exhibit attached to the aren't you supposed to address every single thing? That's why you file them, so you have them on record. The court considered each filing in full. However, to be clear, the court was specifically ruled on the Ramlow affidavit with respect to the defendant's current motion. The Brady violation occurs when the prosecution withholds evidence that is favorable and material to an issue in the case, which we have multiple Brady violations. A Brady violation does not occur when the prosecution fails to turn over the type of information that could form the bias for the further investigation by the defense. With respect to the defendant's theory that Bobby Dassey is a credible third-party suspect, that Ramlow affidavit falls into the category of which could have been from the basis of the further investigation of the defense. Putting aside any credibility issues of the part of the affiant in the affidavit is taken to the true purpose of the motion, established that the victim's rapport was away from the Avery property between the time of the murder and the time it was discovered on Avery property. As discussed previously, there is nothing in any of the exhibits offered by the defendant that established that Bobby Dassey had possession of the vehicle any time before the night that Mr. Sawinski states that he saw Mr. Dassey with it. Nothing in the affidavit of Mr. Ramlow directly links Bobby to the vehicle at the time that was observed by him. Mr. Lewinsky's affidavit only asserts that he saw Bobby pushing the car after Mr. Ramos saw it parked in a different location. There is no exhibit offered that established that Bobby had the key to the victim's vehicle. While Mr. Ramos' information may have been an avenue for the further investigation, the exhibits submitted to not directly connect the Bobby Dassey to the homicide itself and failed to meet the standard under Denny to establish Bobby as a third-party suspect with respect to this crime. As such, the failure to law enforcement to turn Mr. Ramos' statement is not a violation of the constitutional rights and is found in the ruling of Brady. On May 26, 2023, the defendant asked that the court consider another affidavit by Thomas Bruce. In the affidavit, Mr. Bruce attests that the night of November 4th, or the early morning of November 5th, he was performing his duties as a tow truck driver when he observed Bobby Dassey driving a RAV4 on a County Road Q. Mr. Bruce states that the headlights from the truck illuminated the interior of the RAV4 and he could clearly see Mr. Dassey and someone that was not the defendant in the vehicle. The affidavit goes on to state that he was incarcerated for bail jumping in 2006. He reported a story to Brown County Sheriff's Department, who discounted the report. Mr. Bruce then states that he did not discuss what he saw again until sometime in 2016 or 2017 when he mentioned it to his brother. The defendant reports that he received the affidavit on May 10, 2023, but unlike Lewinsky's affidavit, it does not provide information on whether the statements made affidavit were verified and the investigation was completed. Once again, assuming for the purpose of the motion, the facts of the Bruce affidavit were true, the facts do not directly link Bobby Dassey with the murder of Ms. Hallbach. The affidavit asserts that two people were in the car when it was seen driving down the road. While Ms. Bruce states that he has conclusively identified Bobby Dassey in the car, he cannot identify the other individual in the car other than eliminate that the person being the defendant. Once again, the affiant links Bobby Dassey to being in the possession of the RAV4 after the homicide took place. There is nothing in the affidavit that establishes that Bobby had possession of the conclusive possession of the vehicle prior to that time. Well, we got Blaine Dassey stating he's seen Bobby in a similar vehicle that looked like Teresa Hallbach's. We got multiple, and it's leaving the property, not on the property. We got multiple people stating they seen the vehicle parked at the turnaround. Now we have people saying that they're witnessing the car coming to the Avery property. But the key to the car itself prior to that night, after only taken as true, established that Bobby was in possession of the car on November 4th and 5th. However, even by that final statements, Bobby was not the only person in the car that night. Nothing in the statement links Bobby to the homicide itself. Well, then why doesn't Bobby Dassey want to talk to Kathleen Zellner's investigators? But he has no problem talking with law enforcement again. And he's even asking law enforcement, well, why is she coming after me? Because it don't look good for you, buddy. Previously discussed, no direct evidence of the matter links Bobby directly to the murder. I disagree. Furthermore, in his affiant, a new unnamed individual could equally be implicated as the murderer in the case under the theory. Mike Osmondson, the unnamed individual, blah, 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 blah. The unnamed individual had equal access to the car the key night in question. That individual could have been the individual who, in the defense theory is correct, could have moved the car back and forth from the property, removed the personal electronics from the car, possessed the key, and planted the defendant's home. Dude, this shit is fucking stupid. As such, the affidavit offered also fails to test Denny and Edmonds to provide the existence of the third-party suspect of the crime. In an alternative to this motion under Denny, the defendant asked the court to grant him a new trial in the interest of justice. Given the above conclusions reached with respect to the evidence offered by the defendant, there are no legal grounds to grant such a request. For this reason, set forth above, the motion defendant is denied. Fuck you, Angela Sikowitz.